Welcome back to LexTalks. Legal topics simplified. We're all about making these sometimes complicated legal topics a little bit clearer for all of you amazing law students out there in India.
Absolutely.
So today we're going to untangle some really essential property law doctrines. And these are especially important when you're dealing with mortgages and property disputes.
Right.
Things like the Doctrine of Priority, the Doctrine of Marshalling, and the Doctrine of Contribution.
It's about fairness and balance in property law.
Yeah, it can get really tricky when you have multiple claims on the same property or people trying to figure out who pays what when things go wrong.
Exactly.
So to kick things off, let's dive into the Doctrine of Priority. Now, at first glance, it sounds pretty straightforward, like first come, first served, right?
Mm.
But how does that actually play out in a real estate scenario?
Well, imagine you have a property and there are multiple claims against it.
Okay,
Like, say, multiple mortgages taken out at different times.
right. Multiple mortgages.
Now, to settle any disputes, the Doctrine of Priority, as laid out in Section 48 of the Transfer of Property Act of 1882, comes into play.
Okay, so in simple terms,
The first validly registered claim gets priority.
so even if someone takes out a second mortgage, if there's already a registered mortgage,
Precisely. The second lender might be in a weaker position.
wow, that makes a lot of sense. It really emphasizes the importance of thorough checks before getting into any property deal.
Absolutely.
Due diligence is key. But here's a question.
Mm-hmm.
What if someone tries to, play the system? Like, could they backdate a document or something to get that priority?
That's a great question, and that's where the ethical aspect comes in. The law recognizes that priority isn't just about being first, it's about acting ethically.
Okay.
So no backdating, no fraud, nothing sneaky. If a court finds any hint of foul play, that priority can be completely gone.
So it's not enough to be first, you have to be honest about it.
Absolutely.
That adds a whole new layer of strategy to property law.
Right. And now, moving on to the Doctrine of Marshalling. This doctrine is all about protecting creditors,
Okay.
especially when a debtor has multiple properties, and some of those properties are mortgaged to different lenders.
This sounds complicated. Can we have an example?
Of course, let's say a debtor owns two properties, A and B.
Okay, E and B.
Property A is mortgaged to lender 1.
Okay, lender 1.
But both properties, both A and B, are mortgaged to lender 2.
Got it.
Now, if lender 1 decides to recover their money by selling property A,
Oh, okay, so lender 1 is going after A, but lender 2 has a claim on both A and B.
exactly. And this is where the Doctrine of Marshalling, as enshrined in Section 81 of the Transfer of Property Act, comes in.
Okay, so how does this protect lender 2?
The Doctrine of Marshalling essentially forces lender 1 to first exhaust their claim on property B.
On property B, which lender 2 doesn't have a claim on.
Right. This protects lender 2 from losing out completely since they only had a claim on A.
It's like a safety net, ensuring that a creditor with multiple securities doesn't unfairly disadvantage another creditor.
Precisely.
And again, this highlights the importance of knowing all the claims on a property before you enter into any financial agreement.
Absolutely. It underscores the importance of due diligence.
Okay, so we've got the Doctrine of Priority, establishing a hierarchy based on timing, and good faith. And then we've got marshalling, which acts as a safeguard in these more complicated situations.
Right.
So what about the Doctrine of Contribution? Where does that fit in?
The Doctrine of Contribution comes into play when 2 or more people jointly mortgage their properties to secure a loan.
Okay, so it's about sharing the burden of repayment.
Exactly. Section 82 of the Transfer of Property Act governs this.
So everyone contributes their fair share.
Yes. Everyone contributes proportionally to the debt based on the value of their property at the time of the mortgage.
What if one person pays off the entire loan to avoid foreclosure?
Well, they can then claim proportionate contributions from the others.
So no one gets a free ride.
Exactly.
So we have these three doctrines working together. Priority sets the order, marshalling protects creditors, and contribution ensures everyone shares the responsibility.
They're essential tools for any lawyer dealing with property issues, particularly in India.
Absolutely. Now, you mentioned something earlier, the Doctrine of Subrogation. Can you tell us a bit more about that? I'm curious how that fits into all of this.
Of course. Think back to that person who paid off the entire loan.
Okay.
The Doctrine of Subrogation allows them to step into the shoes of the original lender.
Oh, interesting.
They inherit all the rights and remedies that the lender had.
So they don't just get their money back, they could potentially become the new lender.
That's right.
Wow, that's a powerful move. It shows how interconnected these legal concepts are.
Absolutely. And it's something to keep in mind as you delve deeper into property law.
Okay, that's fascinating. Now, before we dive further into specific scenarios, let's take a step back and talk about property itself. What exactly constitutes immovable property in legal terms? I remember from my early law school days, it wasn't always as straightforward as it seemed.
You're right. It can be tricky.
We tend to think of land and buildings, but is there more to it?
It goes beyond that.
Really?
In legal terms, immovable property also includes benefits arising from that land.
Okay.
For instance, think of a debt secured by a mortgage.
A mortgage on that land.
That would also be considered immovable property.
So it's not just the physical structure, it's the rights and interests attached to it.
Exactly. Think of it as a bundle of rights. The right to possess, to transfer, even to receive future rent, all part of what makes property immovable.
That's a crucial distinction.
Yes,
So when we're talking about these doctrines, we're essentially talking about this whole bundle of rights tied to the property.
precisely. Understanding this broader definition is key to grasping the full scope of property law and how these doctrines operate.
All right, that makes sense. Now, how about we shift gears and talk about the actual process of transferring property? Specifically, this concept of attestation. It sounds very formal.
It is. Attestation is a vital safeguard. Imagine signing a deed or a will.
Right.
Attestation means having witnesses present during the signing.
Oh, okay.
It's adding authenticity and protection against fraud.
So it's more than just signatures. It's about verifying the entire process.
Exactly. It's like a legal stamp of approval on the transaction.
So you need witnesses who actually see the person signing.
Yes, 2 or more witnesses who can vouch for their identity and consent.
And they have to sign the document too.
Yes, confirming their presence.
I see. So there's a procedure to make the attestation legally valid.
Absolutely.
And this prevents forgeries and ensures the integrity of transactions.
Precisely. And the Indian legal system has clear guidelines for this. Section 3 of the Transfer of Property Act. While it doesn't specify a format, the process itself is crucial.
Okay, so there's no room for sloppiness here.
No, not at all.
Precision and adherence to procedure are key.
Now, this attention to detail is even more critical when dealing with family arrangements related to property.
Oh, right, because families and property can be a tricky mix.
Exactly.
So how does property law navigate these potentially choppy waters?
Well, the interesting thing is that family arrangements can even be reached informally, sometimes orally.
Oh, really?
But to hold legal weight, especially with property involved, it needs to be put in writing.
All right.
This documented agreement helps clarify everyone's rights and prevent future disputes.
So putting it in writing is like creating a clear roadmap to prevent misunderstandings and conflicts down the line.
Exactly. It brings certainty and transparency.
Now, does this written agreement also need to be registered? Because I know registration is a big deal in property law.
You're right. Registration is crucial, especially for transfers of ownership. But with family arrangements, there's a nuance. If the written agreement just documents a pre-existing oral agreement, registration might not be mandatory.
Oh, interesting. So it depends on whether the written document creates the arrangement or just confirms an existing one.
Precisely. Indian case law provides guidance on this. Ultimately, it boils down to the intent and purpose of the document.
It sounds like there are layers to this, really emphasizing the need for a skilled legal professional to guide these families through the process.
Absolutely. It's not just about the principles, it's about applying them to specific situations.
Okay, before we wrap up this section, let's talk about conditional transfers of property. What does that mean?
Think of it as transferring property with strings attached.
Okay.
Someone wants to transfer property, but only if certain conditions are met.
Ah, like you can have this property, but only if you use it for this specific purpose.
Exactly.
So it's not a straightforward transfer. There are stipulations involved.
Right. And Section 25 of the Transfer of Property Act outlines the rules governing these.
Okay.
The condition attached to the transfer has to be legally valid and enforceable.
It can't just be any random condition.
Right. It has to hold up in court. It can't be impossible to fulfill, like, you must build a castle on the moon.
Yeah, makes sense.
And it can't be against the law or considered immoral.
So it's about responsible and ethical use of conditional transfers.
Precisely. Now, a common example of this is a vested interest subject to divesting.
Oh,
Imagine someone leaving a sum of money to their grandchild, but only when they turn 25.
so the grandchild has a potential right to the money.
Yes, it's theirs in principle, but it's conditional.
Okay.
If they pass away before 25, the interest is Divested, meaning it goes to someone else.
So like a wait-and-see situation.
Precisely.
The interest is there, but contingent on a future event.
It highlights how property law anticipates future possibilities and creates mechanisms to handle them.
That's fascinating. It adds another layer of complexity,
Mm.
but it also allows for flexibility and tailored solutions.
Absolutely. Now, speaking of navigating complex scenarios, there's this concept called the Doctrine of Election.
Okay, the Doctrine of Election.
It's all about preventing someone from, having their cake and eating it too.
Okay, I like that analogy.
Legally speaking, of course.
Right, legally.
It applies when someone benefits from a property distribution, like a will, but also wants something that goes against that plan.
So they want to pick and choose what they like,
Exactly.
not following the rules.
And that's when the doctrine steps in. They have to choose, either accept the benefits as outlined or give them up and pursue their conflicting claim.
It's like saying pick a lane and stick with it.
Precisely. It upholds the overall intent of the arrangement, ensuring a just distribution.
Okay. Can you give me an example of how this might work in real life?
Sure. Imagine a will states a specific property, let's say a family heirloom, goes to person A, while a sum of money goes to person B.
Okay.
But person B also has a claim on that heirloom based on some prior agreement.
So they want the heirloom and the money.
Exactly. The doctrine of election forces them to choose money or the heirloom.
They can't have both.
Right. It's based on the idea that you accept the whole package or none of it.
Interesting. This highlights the importance of understanding all the details of a legal arrangement before accepting anything from it.
Absolutely. It's about knowing what you gain and what you might have to give up.
Now let's talk about income generated from a property,
Okay.
especially when ownership is being transferred.
Mm-hmm.
There must be some gray areas when it comes to who is entitled to what, right? Like rent or dividends.
You're absolutely right. That's where apportionment comes in.
Apportionment.
It ensures a fair division of income between the old and new owners. Imagine selling a property mid-year with an ongoing lease.
Okay, so the rent payments would need to be divided fairly between the seller and the buyer.
Exactly. Section 36 of the Transfer of Property Act governs this. Periodic payments, like rent, they accrue daily.
Daily.
Yes, to ensure a precise division.
So even if you only own the property for part of the year, you get your share of the income.
Exactly.
No unfair gains or losses for either party.
Apportionment ensures a fair and equitable distribution.
Okay, so we've covered apportionment when the property is being sold.
Mm-hmm.
What about situations where multiple people own a property together and those benefits or obligations need to be divided?
That's apportionment of benefit or obligation on severance.
Okay,
Imagine a jointly owned property with an obligation like property taxes.
so it's about dividing responsibilities among co-owners.
Precisely. Section 37 of the Transfer of Property Act provides guidelines for this. When a property is divided, the associated benefits and burdens should also be split fairly.
So if 3 people own a property equally and the annual tax is 300 rupees, each person pays 100 rupees.
Exactly. And it applies to benefits, too, like rental income. The key is fairness, preventing anyone from being unfairly burdened or disproportionately benefited.
This could involve some careful calculation and perhaps some negotiation.
It can, yes. Clear communication between co-owners is essential.
Now, you mentioned apportionment applies when property is divided. But what if one co-owner sells their share? How does that affect those existing obligations?
That's where Section 40 of the Transfer of Property Act comes in.
Okay.
When a co-owner transfers their share, it doesn't necessarily release them from pre-existing obligations.
So even if you sell, you might still be responsible.
Yes, if the new owner was aware of those pre-existing obligations.
Aware.
Yes, they had notice. It's about protecting the integrity of existing agreements.
Okay, so transparency is key when buying a share of a property.
Absolutely. It minimizes potential disputes.
And this applies to more than just finances, right? Like easements or restrictions on how the property can be used.
Exactly. Like an agreement for a common pathway, that would still apply even if ownership changes.
Right.
It ensures the original intent of the agreements is respected.
Now, what happens when someone acts as the owner of a property, even if they don't actually own it? How does the law handle that?
That's where ostensible ownership and the principle of estoppel come in. Let's say X acts as the owner with the actual owner's consent.
So they're presenting themselves as the owner.
Yes. Now, if X sells the property to Y, who doesn't know the real situation, Y is considered a bona fide purchaser acting in good faith.
So the sale to Y could be valid even though X didn't have the right to sell.
Exactly. Section 41 of the Transfer of Property Act protects such buyers.
That's a crucial protection for buyers who could be misled.
It is.
Are there specific conditions for this protection to apply?
Yes, the buyer must demonstrate good faith and that they took reasonable steps to ascertain the seller's authority.
So it's about encouraging responsible buying practices.
Exactly.
But it also emphasizes the importance of due diligence.
Absolutely. Now, when we're talking about multiple owners and property transfers, it reminds me of joint ownership. How does Indian law distinguish between different forms of joint ownership, like joint tenancy and tenancy in common?
That's a good question. They both involve shared ownership, but I'm not sure about the legal differences.
They have significant implications, especially when a co-owner passes away.
Oh, okay. So the way ownership is structured can affect inheritance.
Absolutely.
Okay.
Joint tenancy is characterized by the right of survivorship.
Right of survivorship.
If one joint tenant dies, their share automatically goes to the surviving tenant, not to their heirs.
So it bypasses inheritance. Is that
Exactly.
common in India?
It's not very common except in specific cases like coparcenary under Hindu law.
Okay. So there are exceptions.
Yes. But generally, Indian courts favor tenancy in common.
Okay. So how does tenancy in common work?
In tenancy in common, each owner has a separate share. There's no automatic right of survivorship.
Yeah.
If a tenant in common dies, their share goes to their heirs as per inheritance laws, not to the surviving co-owners.
So it's more in line with the typical inheritance process.
Exactly. Section 45 of the Transfer of Property Act helps determine whether a transfer creates a joint tenancy or a tenancy in common.
It sounds like it's crucial to understand the implications of each form of joint ownership.
It is. Choosing the right structure can have long-term consequences.
Okay. Now, let's circle back to the doctrine of priority. We talked about it establishing a hierarchy, especially with mortgages.
Right.
Can you walk us through how it actually works in practice?
Absolutely. The Doctrine of Priority, as laid out in Section 48 of the Transfer of Property Act, basically says that when you have multiple claims on the same property, the first claim in time wins as long as it's valid.
So it's like the early bird gets the worm.
Precisely. But there are exceptions where priority can be lost even if you're first.
We touched on those. Fraud or negligence can affect priority.
Exactly. Let's say someone takes out a mortgage from lender B. Then they take out a second mortgage from lender C.
Okay, so B has the first mortgage, C has the second.
Correct. Now, if the borrower defaults on both loans and the property is sold, lender B gets paid first from the sale proceeds because they have the first mortgage.
Ah, so it's a clear order based on when the mortgages were taken out.
Precisely.
This is crucial for fairness and transparency when multiple parties have a financial stake in the same property.
Absolutely. Now, as we mentioned earlier, there are situations where this priority can be lost.
Right, like fraud or being negligent.
Exactly. For instance, if lender B colluded with the borrower to hide the first mortgage from lender C, they could lose their priority.
So honesty and transparency are key.
They are. And then there are legal instruments or agreements that can override the typical rules of priority.
Oh, interesting. What kind of agreements?
Things like a priority agreement between lenders.
Priority agreement.
Yes. It might state that even though lender B has the first mortgage, lender C gets priority in claiming their dues.
So the lenders themselves can change the order.
Exactly. This is common in complex financial transactions.
It sounds like navigating this doctrine of priority needs a deep understanding of legal principles.
It does. And expert legal counsel can be essential.
Now, before we move on, can you explain tacking? I've heard it's related to the doctrine of priority.
Tacking is a way for a second lender to essentially combine their claim with the first lender's claim.
Okay.
This strengthens their position against other claims.
So they're teaming up.
You could say that. For example, if the first lender needs more money, a second lender might provide it, but only if they get a better position in return.
So it's a win-win for both lenders.
It can be.
Are there any rules around tacking?
Of course. For instance, the first mortgage must be valid, and the second lender must be acting honestly without knowing about any other claims.
So there are safeguards against abuse.
Absolutely. Courts will scrutinize these arrangements to protect the rights of other creditors.
It sounds like tacking adds another layer of complexity to property law.
It does. But it's an important mechanism to understand.
Okay, so we've talked about how claims are prioritized. But what happens when a property is sold to settle unpaid debts?
Hmm.
What's a revenue sale?
A revenue sale happens when the government sells a property to recover unpaid taxes or other government dues.
So the government is using the property to get back what it's owed.
Exactly. Imagine a property that is mortgaged, but the owner hasn't paid their taxes.
So a mortgage and unpaid taxes.
Yes. In that case, the government might conduct a revenue sale.
Okay.
And Section 73 of the Transfer of Property Act protects the mortgagee's interests in such a sale.
So even though the property is being sold for unpaid taxes, the lender's claim isn't completely gone.
That's right. The mortgagee can claim their dues from the proceeds of the sale as long as they weren't responsible for the unpaid taxes.
That's important. Their investment isn't completely lost because of the owner's tax problem.
Exactly. It's about fairness and recognizing the separate nature of the mortgagee's claim.
Okay, that makes sense. But what happens if the money from the sale isn't enough to cover all the debts?
That's where the Doctrine of Priority, which we discussed earlier, comes back into play.
So the hierarchy of claims applies in a revenue sale too.
Yes, the same principles apply.
Secured creditors, like those with mortgages, are higher up in the order.
Exactly. And among secured creditors, those with earlier claims generally have priority.
This ensures fairness in how funds are distributed.
It does. And this applies not just to mortgage dues, but also to government dues and any other legitimate claims on the property.
It sounds like a complex system, but it's designed to ensure everything is handled in a fair and orderly way.
Exactly. And it's crucial to understand these principles.
Now, what happens to any leftover money from the sale after all the claims are paid?
That's a good question. Any remaining surplus goes back to the original property owner.
Oh, really? So even though they lost the property, they might still get some money back.
That's right. It's a way to balance things out.
It's good to see that the law strives for fairness, even in situations like a revenue sale.
Absolutely. Now, let's shift our focus to the role of a mortgagee in possession. This is when a lender, often because of a borrower's default, takes control of the property.
Mortgagee in possession. That sounds powerful.
It is a significant position. They have specific rights and responsibilities that are different from a regular mortgagee who just holds the mortgage.
Okay, so they're not just holding a claim, they're actually managing the property.
Exactly. While the Transfer of Property Act doesn't explicitly define mortgagee in possession, it outlines their actions, such as their power to lease the property.
Oh, interesting. So they can lease it out while they're in control.
Yes, that's addressed in Section 76. But remember, they have responsibilities as well.
What kind of responsibility?
Their main duty is to use any rental income responsibly.
So they can't just spend it all.
No. They have to prioritize expenses related to the property's upkeep, taxes, and, of course, repayment of the mortgage debt.
So they're like caretakers, making sure the property is looked after.
Exactly.
It's a balance between their interests as a lender and their responsibilities toward the property and the original owner.
Precisely. They're accountable for their management.
It's good that the law recognizes this, even when a borrower has defaulted.
Absolutely. Now, another interesting aspect of being a mortgagee in possession is their right to make improvements to the property.
Oh, really? So they're not just keeping it as it is, they can actually invest in making it better.
That's right. Section 63A of the Transfer of Property Act covers this. They can recover the cost of those improvements if the property is ever redeemed by the original owner.
That seems fair. If they're spending money to improve the property, they should be able to recoup those costs.
It is. But remember, these improvements must be reasonable and necessary. Courts will make sure the original owner isn't being unfairly burdened.
Okay, so it's not just a free pass for them to do whatever they want. There are limits and oversight.
Exactly. It's about balance and fairness. Now, what happens if the lender wants to go beyond just recovering their money? What if they want to own the property outright?
That's where foreclosure comes in, right?
You got it. Foreclosure is a big step, and we'll explore that in more detail in the next part of our deep dive.
Exactly. It's the legal process that allows the lender, the mortgagee, to take full ownership of the property if the borrower, the mortgager, can't pay back the loan.
So it's the ultimate consequence for the borrower. They lose their home or property.
It is a serious matter with significant consequences, and that's why there are specific legal steps that have to be followed.
Okay, so it's not a simple process. It's not just a matter of the lender taking over.
No, not at all. It involves a formal legal process and court oversight.
So the courts are involved to ensure it's done fairly and by the book.
Exactly. Now, in India, foreclosure is mostly connected to Mortgages by conditional sale.
Right, we talked about those earlier. That's where the possibility of foreclosure is built into the mortgage agreement itself.
Exactly. If the borrower can't repay within the agreed time, the lender's ownership becomes absolute.
So it's a different situation from a regular mortgage. Yes, it is. In a simple mortgage, the borrower keeps ownership and just gives the lender an interest in the property as security.
So the type of mortgage really matters.
Absolutely. It affects the rights and options of both the lender and the borrower.
Okay, so let's say a lender wants to go through with foreclosure. What does that process look like?
They have to file a suit for foreclosure in court.
Sue for foreclosure.
They're asking the court to declare that the borrower has lost their right to redeem the property, basically, that the lender now owns it.
So the court needs to be involved to make sure everything is legal and justified.
Exactly. The court plays a crucial role, examining all the details and ensuring fairness.
So the court acts like a referee in the process.
You could say that, and the court will usually give the borrower one last opportunity to save the property by paying what they owe.
So there's a chance to redeem it, even at this late stage.
Yes, there is.
What if the borrower still can't pay?
Then, the court issues a decree of foreclosure.
Decree of foreclosure.
This officially ends the borrower's rights, and the lender becomes the owner.
Wow, that's a pretty powerful legal tool for lenders.
It is, but it's important to remember that it's a last resort, and there are safeguards in place to protect the borrower's rights.
Right, it's not a decision to be taken lightly.
Exactly.
Hmm.
Now, foreclosure isn't the only option for lenders to recover their money. Another option is filing a suit for sale.
Okay, so if foreclosure isn't an option or they choose not to go that route, what's a suit for sale?
In a suit for sale, the lender goes to court and asks for the property to be sold.
So they're not taking ownership. They're forcing the sale of the property to get their money back.
Precisely. The money from the sale is used to pay off the mortgage debt, and anything left over usually goes back to the borrower.
What if the sale doesn't bring in enough to cover the entire debt?
Well, depending on the mortgage agreement and the law, the lender might be able to go after the borrower personally for the remaining balance.
So they have some options to try and recover the full amount?
Yes, they do.
It's good to see that the law tries to strike a balance, protecting both lenders and borrowers in these situations.
Absolutely. The goal is fairness for everyone involved. Now, let's think about the people who help a borrower repay a debt, like a guarantor. What rights do they have?
Right, what happens when a guarantor steps in to save the day?
That's where the doctrine of subrogation comes into play.
Okay, we talked about this a little earlier. It's the idea that the person paying off the debt gets the rights of the original lender.
Exactly. So if a guarantor pays off the mortgage for the borrower, they basically step into the shoes of the lender.
So they have the same right to demand repayment from the borrower.
Precisely. They inherit all the rights and remedies the original lender had.
It's encouraging to know there's legal protection for those who act in good faith to help others.
Absolutely. The doctrine of subrogation is all about ensuring fairness and accountability.
So it's not just about getting their money back. They actually acquire the lender's rights.
That's right. They can even take legal action if necessary.
Wow, that gives guarantors some real power.
It does. It also makes people more willing to act as guarantors, knowing they have legal options to protect themselves.
Okay, so we've covered a lot of ground, from hierarchy of claims and foreclosure to the rights of guarantors. But I want to touch on one more important difference in property law, and that's the difference between a lease and a license.
Ah, yes, the lease versus license debate. It's a common point of confusion.
It is. They both involve using someone else's property, so what's the difference?
The main difference lies in the extent of rights granted. A lease grants the lessee a legally recognized interest in the property, giving them exclusive possession for a specific period.
So it's more than just permission to use the property.
It is. It's like a temporary form of ownership with specific rights and responsibilities.
Okay, so what about a license?
A license is much more limited. It simply allows the licensee to use the property for a specific purpose. There's no ownership interest or exclusive possession.
So it's about permission rather than transferring any property rights.
Exactly. Think of it this way. A lease gives you the keys to the castle, but a license might just let you walk in the garden.
Okay, that makes sense. So with a lease, the tenant has much more control.
Yes, they do. And they have the right to exclude even the property owner during the lease term. This difference also affects what happens if the agreement is broken. The consequences are more serious for breaching a lease.
So how do you tell the difference between a lease and a license?
Well, courts look at various factors. One key factor is exclusive possession. Does the arrangement give the individual the right to exclude even the owner?
So it's about control and exclusivity.
Right. They also look at the length of the arrangement, how payments are made, and the specific rights and obligations outlined in the agreement.
It sounds like you need a trained eye to differentiate between the two.
It does require careful analysis and a good understanding of property law. That's why expert advice is so important.
Okay, so whether it's a lease or a license, the bottom line is to make sure everything is clear and well documented.
Absolutely. Clear communication and a well-written agreement are crucial for a smooth relationship.
Now, shifting gears a bit, let's talk about notice periods in leases. I know this from renting apartments, but what's the legal side of it?
The notice period is a key part of lease agreements. It provides a structured way to end or change a lease.
So it's about giving both parties time to adjust and prepare.
Precisely. It creates predictability and fairness.
Are there specific rules about how long a notice period needs to be?
Yes, there are. The law requires a reasonable notice period. For example, Section 106 of the Transfer of Property Act deals with notice periods for periodic tenancies, like month-to-month or year-to-year leases.
Okay, and what's considered reasonable in those cases?
Usually, it's the same length as the rental period.
So a month's notice for a month-to-month lease.
Exactly. And a year's notice for a year-to-year lease. Of course, the lease agreement itself can change these default rules.
So it's important to check the
Yeah,
agreement.
always a good idea.
Now, are there situations where a lease can be ended immediately without a notice period?
Yes, there are. For example, if the tenant seriously violates the lease terms.
Like damaging the property or doing something illegal?
Exactly. In those cases, the landlord might be able to terminate the lease immediately.
So there are protections for landlords too.
There are. But remember, even in those situations, the proper legal procedures must be followed.
So no quick evictions without going through the right process.
That's right.
Okay, before we wrap up this section on leases, I'm curious about lease renewals.
Okay?
What happens when the original lease period ends? Does a new agreement need to be signed?
Sometimes, even if the lease term ends, the lease can be automatically renewed if the tenant stays and the landlord keeps accepting rent.
Oh, interesting. So you might not need a brand new agreement.
Exactly. This is called a tacit renewal.
Tacit renewal, so it's based on the actions of both parties.
Precisely. It's like they've agreed to continue the lease, even without saying so directly.
But does the renewed lease have the same terms as the original one?
Not necessarily. It might become a periodic tenancy, like month to month, based on how the rent is handled.
So there might be changes, even though there's no new written agreement.
That's right. That's why it's always best to have a clear written agreement, even for renewals.
Okay, so good communication and clear documentation are always recommended to avoid confusion and potential problems.
Absolutely. It's essential for both the landlord and the tenant.
Okay, we've covered a lot of ground today, from the basics of property ownership to the intricacies of mortgages and leases.
We've explored a wide range of concepts and legal mechanisms that govern property transactions in India.
It's been a fascinating look at this complex area of law.
It has. And for all our law students out there, I hope this deep dive has been helpful and insightful.
Absolutely. Remember, these concepts aren't just theoretical. They have real-world applications and can significantly impact people's lives.
They're essential tools for protecting rights and ensuring fairness in property transactions.
Okay, so now let's shift our focus to a specific type of sale that often brings these principles into play. We're talking about revenue sales.
Ah, yes. Revenue sales. This is where the government steps in to sell a property because of unpaid taxes.
Right, we touched on that earlier.
It's an important mechanism to make sure people pay their taxes and that the government has the funds to provide essential services.
Okay, so it's a way to enforce tax laws.
Exactly. But what happens when a property with unpaid taxes also has a mortgage on it?
Right, that's what I was wondering. Who has the priority in that situation? Does the government's claim come first, or does the lender still have rights?
That's where things can get a little tricky, and that's what we'll be diving into in the final part of our deep dive. It's a situation where multiple claims could clash, and that's where the law provides some clarity.
Okay, so tell me, does the mortgage get wiped out, or can the lenders still protect their investment?
The law actually protects the mortgagee's interests in these revenue
Oh,
sales.
that's good to know.
Section 73 of the Transfer of Property Act specifically addresses this.
Okay, Section 73.
It gives the mortgagee the right to claim their dues from the proceeds of the sale.
So even though it's a government sale for unpaid taxes, The lender can still get their money back.
Exactly, as long as they weren't responsible for the tax default in the first place.
So they're not penalized for something that wasn't their fault.
Right. It's about recognizing that their claim on the property is separate from the owner's tax problems.
It's a relief to know there are safeguards like this in the system. But what if the sale doesn't bring in enough money to cover everything, including the mortgage, the taxes, and maybe other debts? Who gets paid first?
That's a crucial question, and it's where we circle back to the doctrine of priority, which we discussed earlier.
Oh, right, the hierarchy of claims.
Exactly. That same principle applies here.
So even in a government sale, the order of priority determines who gets paid first.
Precisely. It ensures a systematic and fair process.
So secured creditors, like mortgage holders, are usually higher up on the list than unsecured creditors.
That's right. And among secured creditors, those with earlier claims, meaning those who registered their claims first, generally get priority.
It's a lot to keep track of. But it's good to know there's a clear system in place. So what happens if, by some chance, there's extra money left over after all the debts and expenses are covered?
Any surplus from the sale actually goes back to the original property owner.
Oh, wow. So even though they lost the property, they might get a financial windfall if the sale brings in more than enough to cover everything.
Exactly. It's a way to balance things out and ensure that while the government can recover its dues, the original owner isn't completely left out.
It sounds like a fair approach, recognizing that both the government and the original owner have some rights and interests in the property.
Well, I think we've really covered a lot of ground today. We've gone from the basics of property ownership to the complexities of mortgages, leases, and revenue sales.
We've certainly explored a lot of legal intricacies. It's amazing how much goes into ensuring fairness and transparency in property transactions. There are so many safeguards and principles designed to protect everyone involved. I hope all of our listeners, especially our keen law students in India, found this deep dive helpful and insightful.
It's always a pleasure to shed light on these often complex topics. And remember, property law is a constantly evolving field, so continuous learning is key.
Absolutely. Thanks for joining us on LexTalks, Legal Topics Simplified, and don't forget to subscribe and stay tuned for more in-depth discussions on all things law. We're here to make these legal concepts a little less daunting and a lot more accessible for all of you future legal eagles out there.